Thank you so much. Welcome again to the Joint Select for the Jamaica Teaching Council Bill. We'll move on to confirmation of the minutes of the meeting held on Thursday, June 13th, 2024. And we'll begin with page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. All right, in the middle of the page, Mr. Nash, on page 9, Mr. Nash has indicated, if you count in the paragraphs, would be 1, 2, 3, 4, 5. The fifth paragraph starts with the number 6, the Commission may, and if you get down to third to last sentence, that starts with he stated. You said you would you'd separate these two. So instead of it just being all in one, it will be two separate sections. All right, and the final page, page 10. So we ask for confirmation of the minutes. Remember? Seconded. We'll move to matters arising from the minutes. Well, I know we have a number of areas in which the technical persons were provided with additional time. So, Mrs. Gordon-Jones, would you like to begin there in terms of the items that you and your team would come back on? So the first one has to do with the roles and functions of the board and the council.
Good afternoon, Chair, members of the committee, colleagues, all. So the technical team met in relation to the issues that we had asked time for to address, or those that needed to be addressed based on the last meeting. However, we are still to go through the matter of the board and the council, the functions of the board and the council under the bill. And so A meeting is scheduled for the coming week to treat with that, with the legal reform department and other technical team members. And so we should be able to provide that response at the meeting that is scheduled for next week, Thursday, in relation to the board and the council. However, Chair, you'd see under this same matters arising, there is also the matter of the transitional provision that we were asked to determine whether a transitional provision is needed for those persons who might be in the system now that at the passing of the bill may be affected if they are not qualified. So the team looked and we discussed, and based on Dr. Gordon's information that she provided, the transitional provision is not needed because those persons who are currently in the system as level 3 heart individuals, they will be qualified for an authorization to teach. And so on that basis, the transitional provision will not be necessary. However, Chair, in relation to the authorization to teach, Dr. Gordon intimated that it ought to be for a maximum period of 6 years. However, the bill currently does not indicate the maximum period. It only indicates that it's the authorization to teach is for 2 years, and they can apply for a further period, a 2 years interval. But what Dr. Gordon is saying, the rationale for the 6 years maximum is to, by the time those 6 years, those persons should be able to attain qualification that would require them to have a license. And so the authorization to teach is not supposed to be a indefinite thing. So that is a matter that the committee would need to consider.
So those persons would require at least 4 years to get themselves to the level of attaining first degree? Mm-hmm.
What I would want to understand, so we speak in the first instance of a maximum of 6 years. And then we spoke about an application every 2 years. Which one are we working with? Is it automatic that this transitional period, in order to gain qualification, will be at a maximum of 6 years?
So it's not a transitional, okay, in the bill it's not noted as a transitional provision. However, anyone who applies for and is granted an authorization to teach, that authorization to teach under the bill lasts for a period of 2 years.
2 years.
It
right.
can be renewed for a further period not exceeding 2 years for each period. However, what Dr. Gordon is saying, that person should not hold an authorization to teach for more than 6 years, because during those years, that person is expected to
Have matriculated.
Right.
And so the threshold for that is the 6 years.
Correct.
Okay. I just wanted to clarify, what the defined threshold would have been to allow the person to be able to matriculate. You made mention of what would have been appearing as a minimum requirement in the system for the heart level, was it level 3? Level 3. That would have been the minimum requirement.
Right.
So suppose, for argument's sake, there are persons on the appointed day does not have that matriculation, and they are in the system.
I will allow Dr. Gordon to respond to that because she has more information in that regard.
And so
Before
again, it would be important to have an appreciation as to the data, if there are any data available existing for us to ascertain the levels of persons within the system that don't have that level of matriculation. And Dr. Gordon usually uses a school down at a particular place that I can't recall. So if it's down that place,
Washfoot Gully.
Yes, thank you. Oh, that's the place, Dr. Gordon.
All right, quick question to Mrs. Gordon-Jones. This would be a new, if agreed, this would be a new clause inserted?
It's based on clause 44 that currently treats with validity of license and authorization to teach, specifically 44.3, which speaks to the period for the authorization to teach.
Okay, all right. Please go ahead, Dr. Gordon.
Thank you, Chair. Good morning, everyone. We are going through times when we need to make changes in the system and assure quality of education and assure who teaches. A person who has attained level 3 in the HEART program is qualified for entry to the Teachers College. And therefore, we agreed to give that person authorization to teach for up to 6 years. That will give the person enough time to complete a college course. There are some persons, I'm sorry we don't have the data because this is really the responsibility of the Early Childhood Commission, so we don't have the data. There are some persons who are attempting to teach who do not have the qualification. They have not attained level 3 of HEART. They are caregivers, and it is better to give care than to teach badly. So we are discouraging teaching by those persons. The commission, the Early Childhood Commission, will have to address the matter. But it's better to just care a child and don't attempt to badly teach the child.
All right, so members, unless there are any objections, I think we could agree to the maximum of 6 years to allow someone who, on the date of effect of the bill, is at, say, a level 3 in the HEART program, that would qualify that person for entry to a teacher's college, to allow that person up to 6 years to get qualified to at least the first degree level. So agreed, members?
No, sorry, Chair?
Yes, please go ahead.
Hi, good afternoon. My understanding of what is being proposed is an amendment to the provision in the bill regarding the period of duration, the maximum duration period for an authorization to teach, to increase that maximum period to 6 years, not a proposal to amend the transitional provisions in the bill, which is a distinct thing from what you've just articulated for the committee. I'd be grateful if the understanding is clarified.
All right, Ms. Gordon-Jones?
Yes, Council, the proposal is for the period for the authorization to teach should be a maximum period of 6 years. Currently, the bill does not indicate a maximum period.
Well, doesn't it? From clause 44 that you read from, sub-clause 3 says the period specified in the authorization to teach shall not be longer than 2 years from the day the council grants the authorization to teach and may be renewed for further periods not exceeding 2 years for each period. I understood that to be a maximum period. So there is at the moment provision for maximum period. And my understanding from what has been articulated is a desire to change that maximum period from 2 years to 6.
No, Council, it's for the period that a person can be granted an authorization to teach. So the person will not be granted an authorization to teach for more than 6 years in total. So currently it's not exceeding 2 years for each period, so it would allow, once the person's authorization to teach is expired, that person would be able to apply for a further period of 2 years. So now we are stipulating that those periods should not exceed 6 years in total. So after 6 years, the person should be applying for a license and not an authorization to teach.
Okay, thank you. That wasn't my understanding initially. I appreciate the clarification. If that's the case, I'd only raise for the committee to consider whether, there may be, let's back up. My broad understanding of the bill is that authorization to teach will be granted to those persons who, let's say, maybe are not teachers as yet, but want to become teachers, or people who have no interest in being licensed teachers, but want to teach in school or in a school setting. Examples given in past meetings include technicians and persons like those. If you specify in the bill that the authorization to teach can be granted for a maximum number of renewals, you might want to consider whether that might have the effect of excluding those types of people from the system. For example, if they have no desire to, go to teacher training school and do a degree and so on.
Thank you for that, Council, because those were my exact concerns when we had the discussion at our meeting since week. But Dr. Gordon had a different view of it. And Chair, I'm not sure if you would allow Dr. Gordon to respond to this, but I shared a similar concern as well.
Please go ahead, Dr. Gordon.
Thank you, Madam Chair. At the moment, the system has resisted having people who are not trained teachers, the tradesmen, serve the system for any prolonged period. It has resisted. And I doubt if we have very many of them. In addition to that, VTDI offers a special program for tradesmen that's accepted as a trained teacher's certificate program. So I don't think that's a concern. And those tradesmen who want to continue to teach, at some point, they must complete that pedagogical program. and it is acceptable.
Chair, may I?
Please go ahead, Mr. Foreman.
Right. I thank Dr. Gordon for that that comment. I don't think it addresses the point that I raised, which is that if you have if you specify a maximum duration for holding an authorization to teach, it means that when that maximum duration has been met, somebody who wants to teach would by that time need to be able to become a licensed teacher, right? And the bill has a specific definition for what constitutes a teacher and the requirements for being a teacher, including having, I believe it's a bachelor's degree or some other training in
Related training.
Related training and so on, right? So let's use the 6-year maximum authorization to teach. A person who has a specific skill, let's say in one of these STEM areas that CXC wanted to cut out examinations for. That a school has that person on staff helping to deliver teaching instruction in that program. That person gets the authorization to teach, renews it once, renews it twice, renews it a third time, reach the maximum of 6 years. The proposed amendment would have the effect of saying to that person, you can't come back again into the system to deliver these instructions that you were delivering because your period of authorization to teach is at its maximum. If you want to come back to teach, you need to be a teacher, which would mean having the requisite degrees. Now, there's an assumption in what was articulated that the individual is going to be so in love with the teaching that they're going to spend the time to go under the 3 years at university and so on and so forth. But the other side of it is that the person may say, I'm too busy doing my profession as a plumber, electrician, whatever other related field they are in. If the system doesn't want to facilitate me anymore, well, that's it. I'll go focus on making money doing something else. If in effect, I'm just want to make sure that the committee, whatever decision it takes, understands the potential consequences of having what would essentially be a cutoff, what might be a sort of a cutoff point for persons who might not be interested in going back to school to become to meet the qualifications of being a formal teacher for the committee's consideration.
No, please remember that we adjusted the definition of the requirements for a teacher to accommodate some special certificates relating to the trades. As I've said before, the system has resisted that approach. And so I don't have the figures here, but there are not many persons, tradesmen, who have not been exposed to any kind of pedagogical training in the system now. So UTech program, the UTech program for the TechVoc teachers has been expanded. So we have, each year we have graduates, we have to try to keep them. The VTDI offers a special program that the ministry has approved, UCJ has accredited for tradesmen who want to continue to teach. And we accept that certificate. It is a teacher training certificate. It is not a period, it is not undertaken over a period of 4 years. It was crafted for tradesmen.
Chair, I understand what Mr. Foreman is seeking to guide the committee on. and we would have established the criteria for those who are desirous of being teachers, starting from the registration, seeking the authorization to teach, and ultimately getting that license to teach. And we would have moved the specification for a period of up to a maximum of 6 years to allow those persons who would have been operating as teachers, having the authorization to teach, and now to be able to move to that glorious threshold. Now, there's always going to be persons who are either support, trainers, coach, instructors. Farmer Joe from Portland who comes to Kingston to support the agricultural science teacher, but has no intention of becoming a teacher because Farmer Joe wants to tend to his farm. And so I don't see us prescribing in law that obligation for Farmer Joe to be getting all those qualifications. It may be a school's policy. Yeah? It may be a requirement of a school if they so desire, but I'm not seeing us prescribing that into the legislation. Allow for the intention of those that the legislation covers to be so prescribed. So I wouldn't necessarily want to go there where Dr. Gordon would have sought to take us.
I say that Farmer Joe would be assisting. Farmer Joe does not have the pedagogical experience. You can put it in the medical context. The Farmer Joe would only be assisting a teacher who has the pedagogical skills. Farmer Joe would come and show the practice to the students, but he would not be responsible for the teaching in terms of how children learn and the care of the care of the children and all of what teachers are responsible for. So Farmer Jones can come and he would be invited because he has a certain technical level. At any rate, the tradesmen who come to the schools, they usually have first degree or some qualification similar in their trades. The teaching component of it covers is done in a distance program, and it covers a few months because they would already have the technical qualification. So they working with the person on how to teach is not a hard program, but it would be unfair to the children to have somebody who is highly skilled but cannot transfer his skill. And that happens, which is one of the reasons why the ministry has resisted the approach over years. It has.
You have some teachers who still like that too. You know?
So, members, I think if we do not have this cap, we're going to have a major loophole in the system. If we don't have the limit on the authorization to teach.
No, sorry, Minister.
Yes.
Sorry to interrupt. I'd just like to remind the committee that the way it's now structured is that it's a 2-year period and renewals are not automatic. The council has to decide whether to renew the person or not. So that there's a degree of flexibility in the bill as it's now crafted that would allow various policy considerations to come into play depending on the exigencies of the teaching scene at a particular point in time. So there's no guarantee that somebody is going to forever and ever be granted the authorization to teach. And in addition to that, there are some requirements in the bill that govern the circumstances in which the authorization to teach is to be given. And my recollection, I'm trying to find a provision, is that some of those criteria include situations where there are not enough competent people in that particular area to satisfy the needs of the teaching profession at the time. So my fundamental point is that there are degrees of flexibility in the legislation at the moment that would sorry, I think I was muted. Sorry, hold on. Am I being heard?
Yes,
I'm here.
You
All right.
heard.
My apologies. Right. I don't think anything I just said was heard. I'll repeat. I just wanted to point out that the bill in its existing form gives flexibility in decision making, insofar as the renewals are not automatic. The council will have the discretion to renew a person's, it could be a teacher's license, it could be the authorization to teach of an instructor. So there's no guarantee that having, let's say, had an authorization to teach in the past is going to guarantee that you have it in the future. And the bill also has provisions in there which guide the circumstances in which authorizations are supposed to be granted in the first place. I've been trying to find that particular provision, but I think one of the criteria includes the extent to which the particular area for which the authorization to teach is being granted has teachers already in the system or not. So those are other factors that I would urge the committee to consider in its deliberations. Thank you.
But the bill gives flexibility, because it says if there's no other person that is trained to teach, then that is when you seek to get somebody and ask for authorization to teach. Mr. Foreman, in all fairness to the teaching profession, I'm sure you don't give authorization for law to practice in the court. I don't know of any person who has been authorized to practice law in a court and is not trained. And we have to consider that the teaching profession is a profession. And if you're going to permit somebody to perform within the profession, that person must have some skills, some teaching skills. If the system cannot take somebody and say, just continue to work with our children. There are people who are highly skilled who really cannot teach. And that is why the renewal is so important, because that person would have been appraised and a determination taken as to whether or not the person is able to transfer the skills to the children, the students or the learners. So as we move towards establishing quality programs, quality learning experiences, we really must consider who delivers the learning experiences. And I agree with the ministry's policy, which has been so for the last more than 10 years, to resist taking people into the education system, into the teaching program forever, in perpetuity, if they have no interest in developing some of the pedagogical skills. They need some pedagogical skills. And if we say over 6 years, VTDI was set up and has programs for tradesmen, the short-term online programs. And I see no reason, if you want to be teaching in our schools, that you should not pursue one of the programs. And they're accepted as trained teacher programs. So it is not a restriction that is going to affect the system negatively. In fact, it will be a positive for the system.
So, yes, go ahead, please.
Yes, if I may. One of the things to consider in determining whether or not there should be a cap on the number of years that a person can get the authorization to teach is if there is no cap and we use the flexibility that Mr. Foreman was referring to in the bill to determine whether or not to grant an authorization to teach. If somebody comes and they satisfy all the criteria set out in clause 29, how can we say to them, how would we be able to say to them, no, you can't get an authorization to teach, if there is no cap on the number of years? So that is something to think about.
So, Ms. Sherlin, are you saying this does not have a cap? Is that your point?
We don't have a cap currently, and Dr. G is suggesting that we put a cap of 6 years. But I'm saying if we don't, how, and even though there is a flexibility within the scheme, if you don't put a cap, how can you say to someone who satisfies all the criteria specified in clause 29 that you can't get an authorization to teach? If the person meets all of these criteria, yes. I mean, how do you say, no, you can't? You wouldn't be able to say that.
But I thought we always saw authorization to teach as a short-term thing, not something long-term or permanent. That's, that's how I always thought about it.
If it's a vision, then it has to be specified, because persons will think that they can just continue and get an authorization for, unless later down the line an amendment is made to the act, sometime after it comes into effect. Or, as Senator was intimating, that in relation to 29H, the person would have to meet other prescribed requirements, and then you would prescribe such requirements in regulations to say you have to satisfy these additional requirements in order to get an authorization to teach.
Because Chair 29(2)H gives an opportunity to make other requirements as one may see is fit. But going back to 44, because we said we made the assumption that there is some cap, but there's no cap as it is. And 44(3) says the period specified in the authorization to teach shall not be longer than 2 years from the day of the council grants the authorization to teach, and may be renewed for further periods not exceeding 2 years for each period. So I will still have an opportunity to seek an authorization to teach for the next 2 years. And at the expiration of that 2 years, I seek a renewal. And that renewal is a continuous expectation now of a renewal. So, with I'm not sure if it's now a conundrum that you would have this continuous rolling over of an application for the authorization to teach that appears infinite with those persons that you spoke about in 29 that would have met all those obligations but don't have the matriculation that we need. So where do we strike the balance? Because certainly there would have to be, if we're seeking to have a cap, then we may want to seek to amend 44(3).
Chair, under 29, the eligibility for grant of authorization to teach, H speaks to meets any other prescribed requirements for the grant of an authorization to teach. I heard Dr. Gordon mentioning this qualification that is accepted from those persons who are like the technicians and so forth, who would be able to get that authorization to teach. I'm just thinking if some prescription could be made in that regard under regulations to treat with not only those skilled persons, but what might be foreseen for other persons in order to get the authorization to teach. So that would serve as somewhat of a bar if you to get another 2 years. Instead of putting the cap. So I'm not sure if Dr. G, if that
so you'll be seeking to set some eligibility requirements prescribed in regulations.
Correct.
And not confined in the legislation itself.
Right. In order to get a renewal of the authorization to teach.
But Council, with all due respect, you know how that's going to be. It's going to be a rolling 2 years forever into retirement. Because we don't love to make tough decisions. In Jamaica, we don't. It's gonna just be rolling, in my opinion.
The 2 years?
Yes.
No, but so remember now you apply for the authorization to teach and you get it for a period of 2 years. What I'm saying is prescribe requirements so that whenever that 2 years have ended, if that person comes back to renew, if that person does not satisfy the prescribed requirements, then he or she will not be eligible for that authorization to teach.
Right, which is how the law is written. No, right, because it say it may be renewed, right?
Right.
The law currently says, well, not the law yet, but the draft bill says it may be renewed. So it's not a
Right.
must that it will be renewed.
Correct.
But in practice, I'm sure if somebody has an authorization to teach in the first instance and they come back the second time and it's renewed, the third time, as Member Gale said, you begin to set an expectation.
Well, I mean, the bill also allows for setting conditions and all of that. So I'm not sure if it will play out as you're saying.
No, we need to cap it in law. We need to cap it. Because, as Minister said, when in the administration of education, if you don't put a cap on it, 6 years, a cap on it, it will go on and on and on. And even when there are more qualified people to get the job, they won't get it. So we put a cap on it, 6 years. If there's we can negotiate. If it is absolutely necessary, as the bill says, you can't find anybody else. But when you put a cap on it, then the institutions will make a special effort to find a trained person to fill the position. We need to put a cap on it. And I think 6 years, putting a cap of 6 years is reasonable. Because in that period, the person is able to do the 3 month, I think it's 3 or 4 month pedagogical program of the VTDI. And it's an online program. It is earth-shaking, but at least the person who gets some teaching skills should have some competencies to teach. And I think that is more flexible than any other profession.
Members, I am going to recommend that we go with a cap of 6 years for an authorization to teach, because at the end of the day, we really want persons in the profession to be licensed as teachers. I understand why we're allowing this category of persons to be there, but we don't want to swell the ranks of persons who only have an authorization to teach. And again, from just my observations of how things generally work, you apply, you get 2 years, you come back, you get another 2 years, you apply again, and you get another 2 years, because there's nothing over you to say you must get the teachers, the degree in order to continue. There's nothing that says that. So as human beings, we're always going to take the easy way out. And so I am recommending, members, for us to put a cap of 6 years.
Just to give another illustration in terms of the prescribed requirements and that qualification Dr. G referred to, that the technicians are so, it would be acceptable in the system if the technicians have that, even if it is not a degree. What if it is prescribed in regulations that, for example, a person who was granted, if you're granted an authorization to teach for a period of 4 years, in order to get a renewal, you have to have X qualification, something to that effect, in order to not bar someone that you would need in the system, but because he or she would have gotten that authorization to teach for 6 years, would not be able to assist the system. So we would prescribe in regulations in order to fit what is happening in the sector, to ensure that those persons who are in the system, they are so qualified.
That is no different than being in an employment where you would have taken on a position and the employer says to you, if you are seeking to retain this position over a period of time, you need to matriculate. An employer will say you need to have your first degree within a specified period, start the enrollment. What it does is that it seeks to retain the skill, but it also encourages that person to pursue the certification. So there would be no difficulty, because the regulation is really setting some guiding principles, right? And there'd be no difficulty in having in regulations that kind of guidance. It preserves the intention to secure, for the individuals to secure the qualifications. And it's also specified a period of time in which they ought to do so, rather than entrench it in law. That's a kind of softer way of applying the procedure.
Except that the whole intention of this act, us sitting here for the last 2 years, is with the notion in mind that we are uplifting, upgrading, modernizing, improving, whatever the adjective is that you want to use, the teaching profession. And that, we want the teaching profession to be held in the highest regard, and that Jamaicans will know that those who enter and those who are in it, they are so qualified. And I wouldn't want to do anything to water down that ideal that we have for the teaching profession.
The greatest intentions in the world might take some time. There are areas in this legislation that requires the strictest conformity to the profession. We have been at this particular area for some time, debating it. And I think we are moving from the extreme to where we are at a point now where we're seeking to strike a balance. And I believe the guidance in terms of how we can treat it in regulations is a way of guiding the balance. Now, later on, we may seek to amend it when we see how it is going. What I would want us to be cautious of is that whilst we're trying to create the strictest safeguards for the legislation, you have some persons within the system who we may have to massage in order to keep them into the system. And this is one of those areas that I don't see it as being harmful in terms of the approach. We can always later down in the revision of this legislation apply stronger measures if people don't pursue the objectives.
member, over the history, I believe, of the education sector in Jamaica, we have been taking steps to improve the qualification of the teachers who enter. I'm sure if you go back in history, you will see a time when there was probably not a requirement for a degree. But we've come a long way where there is a requirement in place now. We have many teachers' colleges. We have other situations. And I think we should be moving forward resolutely for what we have set out to do, and not to try to find ways to accommodate those who don't want to get the necessary certification, degree, or, the requirement, don't want to fulfill the requirements, but still want to be in the profession. Dr. Gordon, you have many, many years. You want to add anything else?
Yes, Minister, I sit here and I'm surprised at the discussion because, many years ago we had 30% trained teachers in the system. Today we have nearly 100% or untrained teachers. The number of untrained teachers in the system is under 200. We are moving forward. We have had the tradesmen coming in and out of the system. In the 70s and 80s, we had a whole lot of tradesmen. And then UTech strengthened its technical training, and VTDI was established to provide pedagogical support for tradesmen. I see at this point we are to move on. The idea of this whole bill is to improve the quality of education that we offer. We need to move on. If we give persons 6 years to get basic pedagogical qualifications, then it's reasonable. It's more than reasonable. We want to ensure that what we give to our children now is the best of education that Jamaica can support.
Members online, please hear your thoughts. Please share your thoughts. So members, at the heart of this discussion is whether or not we continue to allow a rolling 2 years for someone who only has authorization to teach for 2 years in the first instance, and then they are allowed to reapply. After 2 years, they can be granted another 2 years, and it could keep rolling along at 2 years like that into infinity. We are proposing, Dr. Gordon, myself, we're on the same wavelength here in terms of proposing a cap on the number of years that the person can be in the teaching profession in the category called authorization to teach. And by doing that, we're sending a very strong signal that that person, if they're interested in remaining in the education sector as a teacher, that they would have to get the necessary educational levels, attainment, degrees to remain teaching in our classrooms. All right, Dr. Gordon, there's a question in terms of any comparisons that we would have with other countries.
I can't give you data now, Minister, but most of the other countries that have technical vocational education, people have to be qualified to teach in their technical programs. And you talk about first world countries. Germany has a special arrangement with companies, but they ascertain the quality of pedagogy, they work for it. And they work with the companies, not with individuals.
Right, I agree. And those it's primarily for the hands-on component,
The practical,
the practical component for the children.
The UK, people are trained. They're trained to teach. And here we have UTech. UTech is producing technical teachers annually. Jamaica also produces some technical teachers.
Yes.
Short produces some technical teachers.
Yep. Mrs. Gordon-Jones and technical persons, I'm going to put this to the committee, and so that we can come to who else is there? Okay. Member Miller is in agreement. Yes. All right, so moved by committee members. All right, let's carry on.
The next matter arising under the bill, based on the matter arising under the minutes, based on the last meeting, is in relation to part 8, which treats with the whole matter of reimbursement of salaries. at the meeting of the technical team, it was agreed that since the matter of salary would not be in the purview of the Jamaica Teaching Council, that those references not be reflected in the bill. And seeing that the ministry is currently reviewing the Education Act and regulations in relation to the public schools, we may consider amending the regulations to indicate whatever reimbursement of those funds in relation to suspension or revocation, and in relation to the private schools, those could be considered as per the contractual arrangements with the employer and the employee. And this was supported by our very learned friend, Miss Wilkins, from the Legal Reform Department.
So are you saying this would be taken out? Part 8 would be taken out?
In relation to reimbursement of salaries, the proposal is to have the status quo remain in the bill, to not refer to any reimbursement of salaries.
Okay. All right, can we move on to before we move on, put it to the committee in terms of retaining the status quo, meaning do not refer to reimbursement of salaries in this bill, because salaries are not in the remit of the JTC.
Also move, Chair.
I'm also in agreement, Chair.
All right, thank you, members. And Ms. Gordon-Jones, did you make a point in terms of the private institutions? Could you repeat?
The consideration was that can be treated with as per the contractual arrangement.
Is there a change to be made to clause 66?
That's a different matter arising.
That's a different, okay.
Which I will move to.
Okay,
next.
please go ahead. Okay.
So based on the meeting of the technical team, it was decided that, seeing that it is not mandatory for the private, those employed by private institutions to appeal to the appeals tribunal, it was agreed that the provision should remain. We propose that the provision remain so they can have that as another avenue if they so choose.
So you're saying they can use the appeals tribunal, or they could use
The IDT.
the IDT, okay. All right. I put it to the members. So moved.
So moved, Chair.
Thank you. All right, thank you, members. We'll move on to next part of the clause 66. Mrs. Gordon-Jones.
The other part is in relation to the allowing the tribunal to give reasons if it is not able to provide the response within the stipulated. No, that's not 66, Chair. It would have been 71.
No, I'm looking at page 3 of the minutes, where it says the committee agreed to give the technical team more time to review the issue. Oh, is that the one you just dealt with a while ago, right?
Yes, Chair.
All right, sorry, thank you.
But the other matter arising was in relation to clause 71. Based on our search of the records, it was noted that the meeting that was held on June 2022 of last year, this was extensively discussed. At the time when it was discussed, there were 2 issues. However, the committee had only agreed on one of the 2 issues, which was in relation to changing the 28 days to 42. But there, based on the discussions, there were consensus in allowing the tribunal to give reasons and advise the parties if it's so true, if it's a situation where it could not render its decision within the 42 days. That's located on pages 5 and 6 of number 30, minutes number 30. So even the LRID was also discussed. It was at that in the meeting for June 22 last year. Chair, at that time you had left and Senator Gale assumed the chair. So it was noted that in the LRIDA we saw where the tribunal would have asked for would have given the extension with the agreement of the parties. However, at that time, SG indicated that would not the best approach in this instance, not to have the agreement of the parties, but to advise the parties of the reasons.
Sorry, can you just remind us what SG had guided us towards?
Let me just find.
And if she had given a reason. Whilst we're talking about giving a reason for the tribunal.
All right. Chair, should I read from the minutes or the information that I have from the minutes of that meeting so that Senator Gale can have an understanding? So he said Mrs. Gordon-Jones read section 12, subsection 12(2)(b) of the Labor Relations and Industrial Disputes Act. The chairman, which was Senator Gale at the time, noted it was understood that the provision specified a defined period of extension and provided a level of flexibility with the agreement of the parties involved. Member Hamilton suggested there could be 2 steps instead of 3 steps in the provision in question, which meant it would not include the 28 days. The chairman clarified with Member Hamilton that the step which included the words "not exceeding" would be removed and substituted with the step that sought agreement with the involved parties. Senator Dr. Morris Dixon noted her support for the suggestion from Member Hamilton. Mrs. Aldridge sought the rationale for the decision to include the consent of the involved parties. She noted that majority of other tribunals did not have the suggested requirement. Member Hamilton asked whether the suggestion did harm, and Mrs. Aldred responded in the affirmative. Mrs. Aldred explained that if both parties did not agree, that they could not proceed, and highlighted in addition that the caveat which stated, quote-unquote, reasonably require was included. She explained that the tribunal had to have a good reason for the delay if there was an issue. She noted that if both parties were not in agreement and the tribunal had a good reason, that it would not be able to proceed. She reiterated that this was not a usual provision in these types of provisions. She noted this was a provision for the Industrial Disputes Tribunal, which was understandable given its operations. I'm not sure if that's sufficient, but it went on further.
Well, the tribunal has had that consistent application in practice over decades, certainly since 1975. What are we seeking to do here? Have an application that binds this particular tribunal in the request or on the advice, because it's really an advice to the parties of the need to have an extension. And what we are saying is for it to give reasons, correct?
Yeah.
Right. Reasons for the extension. In my mind, there's no harm in doing that. Once it is viewed that it's an advice, and so that advice will not be exposed to a challenge of any sort. In other words, you provide the reasons to allow the tribunal to complete its work and its findings. It would have been good. There are many tribunals, and tribunals who have been established in law. There is an inconsistency in how they operate. And maybe at some point in time, my trade union colleague who is online and who has not said anything, I've heard at times spoke about the inconsistency of the operations of the tribunal and, has called for some alignment. But in this case, it would be good to appreciate how recently established tribunals operate in this case. But I don't see a harm, Chair, in making a provision that the tribunal ought to give reasons. Because in the very least, giving that reason would allow the parties involved to understand the justifications for any delay. So it would be for the technical team just to indicate what that proposal in draft would look like.
But member, in general, we're saying that
It's
there's
okay
no
to give
objection,
reasons.
right?
It
It's
is,
okay to give
yes,
reasons
it is
for
okay to
additional
give
time
reasons
allow
in my
the
mind.
tribunal
Yeah.
to do their work. So I put that to the members.
I
Well,
was
we'll
trying
have
to trying to drag out Member Brown, but he apparently has difficulties unmuting, I suppose.
Okay. All right. So members, we're pretty much saying the tribunal should be allowed to give a reason for any extension of time that they would require to complete the work that they're doing. So moved?
Yes, so
All
moved.
right,
I'm in
thank you.
agreement.
Yes, thank you. Carry on. Mrs. Gordon-Jones, please carry on. I think we're at clause 81 on page 6. The committee agreed for the technical team to consult on the matter for the correct reading of the marginal note.
Yes, Chair. I think that's the last matter arising. Mrs. Sherland will indicate what the marginal note will now read.
Ms. Sherland?
That's clause 81, registration, licensing, or authorization to teach of eligible persons not currently registered at the appointed day. I think that should, even though it's long, it should capture the essence of the provision.
marginal note. Please read again. Please repeat.
Registration, license, or authorization to teach of eligible persons not currently registered at the appointed day.
Okay. So moved by committee members. So moved. Member Cuthbert and others online. So moved.
Yes, so moved.
Thank you.
Chair, or could I forget transitional provision in relation to employees? Senator Brown's.
No, I thought we agreed already on that.
No.
Didn't we? Yes.
No, it was not agreed on.
Go ahead,
Chair.
Ms. Gordon-Jones.
So based on the review, the clause, we noted that it might not have properly articulated the intent. The intention was to allow those persons who are transferred at the appointed day the 6 months period to decide whether they will revert to their substantive post or resign and take a contract with the council. And so the provision 85.1 would read, subject to the provisions of this section, on the appointed day, a public officer assigned to an office under the existing council shall be transferred to the service of the council established under this act for a period of 6 months or such longer period as the council may, in special circumstances, determine. So the words person holding an appointment or, those were removed and public officer was inserted. I think Senator Brown has a comment. I'm not sure you Senator Gale, I'm not sure why out. Sorry.
I was asked to comment on it, and between the last meeting and today's meeting, I was advised of the clarification that I had sought. In that, what the proposal would have been is that that clause 85, the intention behind clause 85 is to allow a public officer who is transferred to the council on the appointed day to elect within 6 months period, or such longer period as the council in special circumstances may determine, whether he or she wants to, 1, revert to his or her substantive post, or resign from the substantive post and take up a contract with the council. So in my mind, what the clarification chair is seeking to do is to indicate that from the appointed day, the officer would have 6 months in the role. And at the expiration of that 6 months, that officer can either decide to revert to their substantive posts or resign from the substantive post and take up a contract with the council. Right? What I wanted to ensure, again, so the clarity that was being sought is to ensure the protection of those individuals. And there are there's a statement in relation to the transfer. There's a statement in relation to the transfer. And I looked back at there was an example used in the last meeting about TAJ moving from inland revenue. And what was proposed then, in my understanding, is that the employees were placed on secondment in the first instance. Chairman, I will just await. I will just await the conversation between the technical team. So the proposed is that to elect within 6 months period or such longer period as the council in special circumstances may determine. So you have the first instance of the 6-month period, to which gives the opportunity for the public officer to decide if they want to revert to their substantive post or take on a contract with the council. And then, for these, what might be seen as special circumstances, as the council may determine. Now, you may have situations in this case, Chair, where the council, upon its review of the transition, decides that, one, we have not properly filled out the structure and we need to review the structure, or we might not have properly defined roles and functions that are going to be operative in the structure, and we may need some additional time to do so. As in the case between moving from inland revenue to TAJ. And so in that case, TAJ had to utilize the special circumstances to extend the period from 6 months, in my understanding, a further 6 months. So that would be the applicable case. However, I would propose, instead of using the term transfer, use the term secondment, which protects the benefits. It would allow for them to retain their benefits and all associated rights under the practice in the public sector, assuming secondment. So I would want to propose that insertion, substitution of the term transfer and utilization of the term secondment in this case. I know I had made an attempt to do a proposed redraft, but you know, I could never indicate that I'm a drafter in any way, shape, or form. I leave that to people like Mrs. Douglas Sherland.
For those online or technical persons are conferring with each other.
Just for policy, the policy direction, because the term substantive post was mentioned. Is there this new council? What would be the substantive post in this case?
Subclass 3? Are you
Sub-
referring to subclass 3?
A person who held an office or employment on the existing council under a contractual arrangement shall from the appointed day be deemed to continue to be employed to the council established under this act on terms and conditions as are no less in their substantive post. So that the term substantive post is really means where they're coming from. The terms and conditions where they are coming from. That's my understanding of the term substantive post there.
When we refer to substantive post, it would mean that
In
the
other
person
words,
is on
right
secondment.
today, I am an accountant, right? And I'm moving to the council in the same. And so what subsection 3 is saying is that I am moving under terms and conditions that are no less favorable than those enjoyed by me in my substantive post.
Yeah. May I share?
Please go ahead, Dr. Gordon.
The posts we now have are posts approved by the Ministry of Finance with post numbers. So once the agency is established, those posts will go over into the established body, as is no change. So the person effectively would be in the same post number.
So, Ms. Gordon-Jones and team, based on what Member Gale said, I don't think we need to overly debate this here, right? Because I think he's gotten the explanation. for substantive post. Right, that would assume that that person that's working with the JTC currently has come from another position to which they, they were seconded from that position to the JTC. I think that's all it meant when it talked about substantive position, the public officer.
The Chair, in looking at the provision and looking at the TJ Act and the Integrity Commission Act, it treats with two sets of employees, those persons who are with the council on secondment. So they are with the council on secondment, so they would have a substantive position with the ministry. You also have those persons who just have a contractual arrangement, not having a substantive post with the council. So 85(1) should treat with those persons who are on secondment. And then there is normally a provision that indicates that those persons should enjoy no less favorable terms and conditions in his substantive post at the commencement date. And then you will have a provision that also treats with the contractual, the staff that are contracted those who do not have a substantive post. So substantive position referred in clause 3 ought not to be there. In subclause 3.
So let's take them in sequence. 85(1), subject to the provision of this section on the appointed day, a person holding an appointment or assigned to an office under the existing council.
So stop there.
Right. You made reference of secondment.
Right. So it's based on what we are looking at. It ought, and based on the change that we had indicated earlier, it should say, subject to the provisions of this section, on the appointed day, a public officer assigned to an office under the existing council shall be transferred on secondment to the service of the council.
Okay. That I will live with.
And then...
And they speak for the period of 6 months or such longer period, as the council may, in special circumstances, determine. And I would have highlighted what those the special circumstances would have been. All right. So 2 now. Well, 2 is not really.
So there should be a new 2 that indicate that during the period of secondment to the council pursuant to subsection 1, an officer shall be employed on such terms and conditions, being terms and conditions that are not less favorable than those enjoyed by such person in his substantive position at the appointed day.
All right, so these are the persons now that you want to protect their terms and conditions of employment into these rules. So this would be the new 2.
Right, for those on secondment.
For those on secondment, right.
And then the current 2 now will change to 3.
So 3.
And then...
And there's no change to the new 3.
No.
Right.
And then current 3 now will turn to 4.
Right.
However, there would need to be a change to the last part of the sentence to remove substantive position.
A person who held an office or employment under the existing council. So these would have been persons now defined as specific employees attached to the council, the existing council, not a substantive, not anybody seconded, right? Under contractual arrangement, shall from the appointed day be deemed to continue to be employed to the council established under this act on terms and conditions that are no less favorable than those enjoyed by the person in. So you're taking out substantive position.
We're trying to work out what that last part
Should be.
read. But it would refer to the arrangement under the council prior to the
Under
appointed
the-
day. The arrangement with the council prior to the appointed day.
Right, prior to the changeover.
Right.
So,
All right, so members, our technical team has asked for some time to just look at the language and come back with a redraft of that section of clause 81. Sorry, 85. What am I saying? Hold on, 85. Or all right, so you're saying you'll send out a revised, right, okay, of 85, 1? 1 to 4, so 4 will be an additional clause. Okay, so our technical persons will send out to us a revised clause 85, which is the transitional provisions relating to employment of the new entity from the old one, and it will have an additional clause. So for our next sitting, we hope we'll be able to move to the schedule. All right. So for the next meeting date, it was announced to be Thursday, June 27, 2024 at 2 p.m. But I'm being advised that looks like that slot was taken. And so, all right, sorry, my misunderstanding. So our next meeting is scheduled for Thursday, June 27, 2024 at 2 p.m. I know that we may not have member Gail, but I am sure he will get the revised clause 85, and he could, via email, let us know, right, whether or not he has any questions. So the next meeting date is Thursday, June 27, 2024 at 2 p.m. And we're expecting to look through the schedules. Schedules 1 to 6. Right, after we've gone through all of that, yep. All right, members, thank you so much for your continued diligence. I'm sorry, I want to reconfirm, recommit item 3 on the minutes, apologies for absence, and we did have apologies from Member Green, Member Morris Dixon, Member Brown-Berg, Member Nestor Morgan, and Member Ransford Braham. Thank you so much, ladies and gentlemen. Thank you to our technical team for the work that you continue to do. I think we are eventually seeing the light at the end of the tunnel. Yes. Still have a few more sessions to do, but I think I can safely say that in short order, we should be wrapping up the Joint Select Committee. Thank you again, members. It's been a long road. I now move for adjournment of committee meeting. So moved by Senator Gill. Thank you, member.